Hello, myself Vikas Singh, and today we will discuss on the topic women and domestic violence. Let's start. So, can we imagine such a type of strict law which was formed in order to deter crime but caused great injustice? There has been a lot of struggle in order to establish safety of women. Still, the problem is there. Why? There are loopholes in every order of law formed. It seems that many changes applied for the better facility of a women's and for the better protection of women's, but the reality is same. As we know that the most complicated and difficult part for bringing change is the beginning. The approach toward the issue of women's safety has always been defensive rather than being preventive. Let's discuss that what is domestic violence. According to the United Nations, domestic abuse or violence mean a relationship in which a pattern of behavior is used to gain power or dominance over an intimate partner. Abuse can be physical, economical, sexual, emotional, or psychological. Such dominance behavior include any act which frightens, hurts, humiliates, terrorizes, blames, injuries, and wounds. It can happen to any irrespective of race, gender, age, sexual orientation. It is cleared by the United Nations that any person can be the victim of domestic violence. Yes, in most of the cases, it is true that when the word domestic violence is raised, then many of people just think that only women are the victim of domestic violence. But it is wrong. Let's understand with the example. In the case of Sanjay Yadav versus Anita Yadav, the Bombay High Court ruled in the favor of husband. Now, if we saw toward the statistical data, then according to the National Crime Record Bureau in 2019, women faced domestic violence more than any other from crime against women. 4.5 lakh reported crime against women, and 1.2 lakh cases are related with domestic violence. Rajasthan is atop in the reported crime against domestic violence, followed by Uttar Pradesh. Indian law on the matter of domestic violence. The first ever law to define domestic violence in India was the Protection of Women from Domestic Violence Act 2005. It is a parliamentary act which comes into force by October 26. It includes verbal, sexual, social, and economical violence with physical violence. Section 3 of the act defines the term domestic violence as any act of commission or omission or conduct of the respondent shall constitute domestic violence in case it harm or injures the health, safety, life, whether mental or physical, to force her or other to perform unlawful demands like dowry. Domestic Violence Act 2005, as we have discussed, domestic violence include threat to health, life, and safety, harassment, harm, or injury. Punishment under IPC and CRPC. The section 498A, which defines cruelty, deals with the act of cruelty against women committed by husband or their relative. The punishment defined in 498A is imprisonment for up to 3 years and fine. Section 304B of IPC deals with matter of dowry death. If a wife dies within 7 years of marriage with burns or bodily injury by her husband or any relative for any demand of dowry, such death will be considered as dowry death. They can be punished for imprisonment for 7 years, which may extend to imprisonment for life. Section 125 of CRPC Maintenance Order. The provision aims to prevent hardship rather than impose punitive measures. Now, we will discuss some remedies under the Protection Act of Women Against Domestic Violence Act 2005. The first one is right to reside in a shared household, Section 17 and 19. Every in a domestic relationship has the right to reside in the shared household. Protection Orders, Section 18. Section 18 of the Domestic Violence Act 2005 empowers the magistrate to issue a protection order based on their prime facie opinion. Monetary relief, Section 20, means compensation amount which wife can get through court order for a damage. This monetary relief may include loss of earrings, medical expenses, loss of property, maintenance. The Section 21 of the Protection of Women Against Domestic Violence Act grants authority to the magistrate to issue temporary custody order for an child or children involved in the case. The next one is compensation orders, section 22. It empowers the magistrate to direct the payment of compensation and damage for physical and mental injuries caused by domestic violence and some other civil remedies, which are divorce, judicial separation, of conjugal right, maintenance. And now let's move toward the section 113B of Indian Evidence Act 1872. It covers presumption with regard of dowry death when it is questioned whether a person has committed a dowry death of a woman, but it is shown that she was suffered to cruelty or harassment for connection with any demand for dowry soon before death. The court shall presume that such person is reason for her death. Section 86 of BNS. BNS stands for Bharati Nyaya Sanhita. Define cruelty. Any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury, or danger to life, limb, or health, mental or physically. So, as we all know that dowry system is one of the most common topic regarding domestic violence. So, Government of India has provided some relief regarding this. Dowry Prohibition Act 1961, its section 3 defines that make accepting as well as giving dowry an offense. This means if bridegroom's family demands dowry from bride's family and they both are satisfied with this deal, they both will be held liable under this act. And the punishment mentioned in this act is 5 years jail and fine up to 50,000 rupees. Section 4 describe deals with punishment demanding dowry. If a person demand dowry to any member of the family of a bride, will held liable, and the punishment mentioned in this section is minimum 6 months of imprisonment and maximum 2 years and fine of 10,000 rupees. There are some leading cases regarding domestic violence. Number 1, Lalita Topo versus the state of Jharkhand 2018. Indraj Malik versus Sunita Malik 1986. Number 3, Arilal P. Arsora and ORS versus Kusum Narottam Arsora and ORS. Number 4, Sandhya Wankede versus Manoj BR Wankede 2011. And number 5 is VD Banot versus Savita Banot 2012. जैसे कि वुमेंस की इनसिक्योरिटी को देखते हुए गवर्नमेंट ऑफ इंडिया ने और जो जुडिशरी है उसने काफ़ी अच्छे एक्ट जो है वो वुमेंस की सेफ्टी के लिए उनको प्रोवाइड करवाए हैं, लेकिन बहुत सी वुमेंस है जो इसका मिसयूज़ भी करती हैं. सो लेट्स सी सम मिसयूजेज ऑफ लॉ बाय वुमेन. In such cases, a mere complaint of a woman is enough to arrest the husband or his relative. It is a non-bailable and cognizable offense, and many women take advantage of the situation. The National Crime Record Bureau shows that 2 lakh people were arrested in regard to dowry offense in 2012, but only 15% of accused were convicted. For the better understand of this, we can look into a case of Dr. N.G. Dastane versus Mrs. S. Dastane 1975. The conclusion is that there are always 2 sides to a coin. We agree that women have come a long way and still have a long way to cover, but that doesn't mean necessarily we have to depend gender divide. Domestic violence and abuse are a cause to the society, and people who do that are nothing but parasites. But if you misuse these against the innocent man, you are no better. The root of such offense dig deep down in the ground, but are not stronger than your will. We have ever ensured full legal support to the victim of such offense, but now we have to ensure there may not be more victim anymore. There are trivial but revolutionary changes that are needed to be brought about not through law but in the society at large. Remember, law are for the society and of the society.